Hey guys, I know it's been a minute since I put a video out. There's this, I've been fighting those charges from those previous arrests you guys have seen. The cops beat me up, and I got charged with with resisting arrest and harassment of public servant. And of course, they're obvious. They do their interest public duties thing when I was filming them, and then the following day and a half later. I was getting open records request, and they threw me to the ground and broke my wrist. These are back from 2019, October 13th and 15th of 2019. I just beat those charges on officially October 11th of 2021. Spent 14 months in jail with no victim. Total 28 months incarcerated per se, because as soon as you go on bond, you're considered in custody. Without any evidence, no witness, they decided to prosecute. My bond ended up being $1.432 million when it started off at $12,500. Same charges. They kept making my bond insufficient. Judge Sherry Shipman, 16th District in Denton County, just overlooked the fact that the district attorney had no evidence. Had no evidence to even go forward. The police officers had no evidence to go forward with the charges. They had no probable cause for warrantless arrest. The arrest was just ridiculous. And yet they still chose to prosecute me. And, like I said, I spent 14 months in jail because I wouldn't take a plea bargain. They offered me 2 years probation. I told them to keep it. Why would I take probation if I didn't do it? And just as importantly, I have the body camera footage that proves I didn't do it. So if I have the body camera footage that exonerates me, that means the DEA does as well. They chose to ignore it and instead, prosecuted me, which there's no way I think it would take this long. Like I said, total of 28 months altogether. Of those 28 months, 14 months incarcerated. I never once got a chance to go to court to face these charges, not one single time. They kept reset. So they got all the punishment out of it, but I never got a chance to defend myself. Never got a chance to face my accuser. Never got a chance to, and none of that. They just kept getting me on by bond insufficient, and went from $12,500 to $30,000 to $60,000 to $90,000 to $300,000, then to $1 million for the same exact charge. This harassment of public servant and assault, which is ridiculous, without any physical evidence. They cannot go forward with that. And the fact they did is malicious prosecution. That's just the beginning. The fact that the judge is in on it. Judge Sherry Shipman was part of it. She was part of the punch. She was punishing me. She put it on my conditions of bond that I couldn't curse or I couldn't speak to law enforcement. Those things are such ridiculous constitutional rights violations. And as we all know, any judicial order repugnant to the Constitution is void. So it had no legal standing whatsoever, yet she still arrested me for my exercise of my freedom of speech. She put in the conditions of bond, which is completely illegal, unconstitutional orders or unconstitutional conditions. Can't talk to law enforcement. Can't discuss my case with law enforcement. I can't tell them what you guys are doing and how they end up getting away with it for so long. I never was able to face my charges or dispute them or rebut them because they never let me go to court. And then the day of my docket call, because I was taking the trial, they just dismissed all the charges. They just quit. Oh, never mind. Never mind. 14 months in jail. $50,000 in attorney fees, about that much in bonding out. Just never mind. Well, there's legal recourse when your constitutional rights are violated, and I'll leave it at that. But just know that I'm still out there fighting, still out there. We have to hold these people accountable. We have to hold them accountable. It's scary the things they get away with, like you go into court, they have you charged for a commercial crime. The charge is a commercial crime, but they're punishing you as if it's a criminal charge without there being a victim. State of Texas can't be the victim. If a crime to occur, there has to be a person, somebody has to do something to somebody else. The state of Texas is just a, third-party litigant, which is basically the prosecutor representing himself. And I say, this is not legal advice. It's just a suggestion that I looked up. Challenge him on that. You challenge that district attorney. Hey, I want you to give me proof of injury in fact. I'm going to face my accuser. Who's the injured party? No injury, no crime. So how can they go forward and prosecute you or incarcerate you or more importantly, punish you? I wish I had the case law in front of me, but I know that there's two different case laws. When you're arrested, even if you're if you're waiting for your charge, waiting to go to court, you're a pretrial detainee. And pretrial detainees are protected by the 14th Amendment. And pretrial detainees cannot be punished for any reason. That's two SCOTUS decisions that are recently. Pretrial detainees can't be punished for any reason. So how can they put you in jail? How can they make you pay a bond? How can they, if you're in jail, how can they discipline you? They can't, because you are protected by the 14th Amendment and you are innocent until proven guilty. That this fortune acts as a criminal without a conviction and make you think that and treat you like you're guilty when actually you're not. You have to stand up for that. And they get mad and they come at you even harder. That's when you go back and slap that, or not slap, but you go back and call that DA. You know, that district attorney, why'd you go after me? What evidence did you have? Show it to me. You know, depends how patient you are. And you know, we got to be patient because they don't want to go to trial. Because when they go to trial, it's all smoke and mirrors up until that point. When you go to trial, they have to come up with actual hard evidence. If they don't have it, they just dismiss it, which leads them wide open for a lawsuit. Because how'd you get this far in the first place? If you didn't have any evidence, any hard evidence to begin with, not assumptions or feelings, you know, feelings don't count. If they didn't have probable cause for warrantless arrest, they're all on-site warrants. They're all on-site arrests, and then they get the warrant. That's a procedural process, due process violation. And these court officers are guilty of fraud upon the court. Judge Shipman is for sure. These are criminal charges. Fraud upon the court. And so is the district attorney, Jessica Davis. I mean, he knew that he had no evidence, hard evidence, that I spit on that cop because the body camera footage shows I didn't. Period. So how does he go forward? Physical evidence, tangible evidence. You know, it has to have some kind of legal standing even to go forward. But they just ignore that in Denton County. Denton County is guilty of crimes against humanity. And my case, notwithstanding, I saw guys in there that were walking around talking to themselves, obviously schizophrenic or mentally incompetent. They throw them in Denton County on some BS, you know, trespassing charge, which is manufactured. Throw away the key. And these guys are just walking back and forth. They don't even know that they're there. And Denton County ends up collecting their Social Security checks. So these guys are in there for a year on a trespassing charge, which is ridiculous, which is not a crime. So how's it jailable? They go by these ordinances and stuff. And they, you know, words have meaning in law, and they do it across the board. Denton County is a criminal organization. I would even go further than that. They're into human trafficking. I believe. No, I'll stick to that. So I think the CPS, they're in the child trafficking as well. Because the CPS family courts are insane on how illegal they are. I have friends of mine who had unfortunately their kids taken away without any hardcore evidence. It was a hearsay from a third party, and then CPS comes in, sticks their nose in it, which they really have any authority, and they act like they are in some family court where the judge doesn't really have any authority, and then the DA, and then it gets all mucked up, and they're all friends. And in Denton County, the judge, not the prosecutor, but the attorney, supposed to be quote unquote interest of the child, and all of the witnesses and all of the study group they hired to evaluate the worthiness, quote unquote, of the parents being parents, they're all in the same little social clique. And I can't remember the name of it in Denton County, but I'll get back to you and find out. They're all dirty. And so they circumvented the parents. They would have secret court dates and not tell them about it, and they would continue on. So they basically steamrolled over the parents and went around them and made decisions between the judge and the DA and the foster. They would make all these decisions without actually evaluating the competency of the parents as being parents. And the parents there was no injury to child or anything. It was all hearsay of alleged drug use, but there was no evidence of, and the parents even took hair follicle tests, and there was no evidence of drug use. But yet Denton County was sending them to certain doctors would come up with these BS drug charges, you know? But they go to a regular independent clinic, and guys, if you don't know if y'all know or not, but you take a hair follicle drug test, it tells you how much and when and how long ago. You can't hide those. You can't fake those. And so if they came clean one day, they're definitely clean the next. Or if they're dirty one day, they're going to be dirty the next day with a haircut fall. That's not what occurred. It's a travesty of justice, misapplication of law, for sure due process. I mean, equal protection. I mean, it made me sick to my stomach and it's all documented. And people just ignore it. And the FBI is worthless. You can't call them and ask them for help. They don't answer the phone. They don't at all. They'll loop you to some tip center. And they won't take the phone calls. So how can these people be held accountable if you can't even get a legitimate complaint started? I mean, you can't get a complaint because they make it administrative and make internal affairs or whatever. It's horse pocket. You can't. It's hard to file a criminal complaint against a police officer. Not impossible, but very difficult. You got to be persistent with these people. They're public servants. They're amenable to the public, and when they violate your citizens' rights under the color of law. Title 18 U.S. Code 242 states that whenever a law enforcement official under the color of law violates a citizen's civil rights, it's a federal crime. It's a federal crime. But yet they get investigated internal affairs, and of course they find nothing wrong, and they just walk. But they are doing federal crimes, and they're getting the other way. We have to hold these people accountable. Meaning, if the DA doesn't do anything, you got to get after them. The DA in county is a joke. Tracy Johnson's a joke. They pick and choose who they go after. They don't really have any hard evidence, but yeah, they go after them anyway because they're wanting people to sign these plea bargains because they're getting money on it. It's all a scheme. Sitting there in a commercial court, but they're happy with the Article 3 charge, meaning you're in a commercial court for non-commercial for for crimes that don't have an injured party, right? Which is not necessarily a crime per se. It's all commerce. And to be in that court, and I'm not trying to sound like a sovereign citizen, but this is actual application of law. To be in that court, there must be some kind of contract. And that's why the term plaintiff and shout out to Supreme decisions, plaintiff and defendant, those are all civil terms. They're not criminal terms, right? And so if there's a plaintiff, that means that person must have an injury. It's kind of injury claimed. And that injury has to be fairly traceable to me. Or let's say, for example, the state of Texas versus Charles Stark. The state of Texas is saying that me, Charles Stark, I've injured them in some way. And there must be proof of it. And they must be seeking some kind of legal redress. That's how the application of law goes for it to be a crime. Okay? Somebody said that something else happened to them. There has to be an injured person, damage to property, or a felony present police officer. But what they do is in Denton County, these crooks, these criminals, these tyrants, okay, they mix and match the courts. They'll have you in a commercial court and you don't know it, but they'll have you in a commercial court for a commercial crime. But the punishment they have is an Article 3. It should be an Article 3 jurisdiction. So that commercial court, subject matter, they don't have subject matter jurisdiction for like DWI or for without an injury, okay, or let's say minor drug possession or speeding. Words have meaning, you need to learn that. But those aren't they're not crimes because there's no victim, there's no criminal act. They're commercial crimes, and for a commercial crime, for there to be some kind of commerce going on, there has to be a contract. Show me the contract. Indictment, warrant, plea bargain. Those are all commercial terms. They're all commerce, man. It's really sad. I implore you to dig deeper into the law and what's actually going on. Because if you don't object to what's going on, it's assumed that you agree. And that's how they kind of get you in there for bail or bond or those kind of things. Or have you in jail, incarcerated completely. I don't quote me on this, but I believe in order for a charge to threaten any jail time, it has to be like a crime, which means it has to be in an Article 3 court, not in some commercial court, because the commercial courts don't have jurisdiction. They have limited jurisdiction, where the Article 3 court, where crimes must be, have the jurisdiction to put you in jail. And so we as people have to challenge the authority or these jurisdiction of the court. You have to object to it. Challenge it. Hey, you have subject matter jurisdiction on this thing? Because when I'm looking at, be humble about it, say what I'm looking at here is the state of Texas versus Charles Stark on some code, violation of code 24.07. Well, that's a code violation, and it's very vague. The charge has to be specific. Hey, the Philadelphia Eagles are alleging that the Dallas Cowboys beat them every year. That's not fair. So they are injured because their poor little feathers got pulled out. And so now the Philadelphia the Eagles, are taking the Dallas Cowboys to court. Those two corporations, right? Instead of Michael Irvin whooping up on somebody independently. It's just a corporation. It's a corporate, and it's not the same thing. There can't be criminal consequences for a commercial crime. They mix and match them all the time, so you have to dig deeper and ask. You got that piece of paper or your indictment paper or any kind of charge paper that says the state of whatever versus you. Challenge that. Oh, really? What state of Texas? For example, you write to that district attorney, say, hey, I want proof of injury in fact. Or you have the right to face your accuser, okay? Well, how can the state of Texas be the showing injury? They can't. So the prosecutor is basically representing himself. Jesse Davis, you crook. The whole Denton County DA's office, they're crooks, And so they're not even real attorneys. They're a bar. They have a bar card. A bar card is not a license to practice law. I would challenge them on that as well. Prove to me you have a license to practice law. If you don't, everything you do is void. And the prosecutor can't be the witness and attorney. He has to be one or the other. So how can he sit there when you're at a hearing or a call? Mr. Stark, you've been in charge with this. So he's the one naming off my charges. He's the one claiming that injury. Well, how can the district attorney claim that injury? He's a third-party litigant. There must be a victim sitting there. Challenge him on that before you even go to court. Hey, I understand I have a court date, February 17th. And I have no problem getting there, but I just want you to prove to me there's an injury. I'm a proof of injury in fact. There has to be an injury, right? If you're in jail, you can get out. Start that process anyway. I wouldn't say, not rioting, that kind of stuff, but you have to object. If you do not object to the charges or the proceedings that are coming against you, you are basically agreeing to them. And then we all lose that way. We have to start fighting back, and we have to get to know the law. Shout out to San Joaquin, those guys, they're deep into that, applying actual law, federal law, state law, and why they differ and what courts that they're in. I'll keep you guys posted on the civil issues, and I'll leave that at that. But guys, please feel free to leave comments. And if I'm wrong, please quote me or let me know where I went wrong on these kind of statutes and codes that I'm spitting out there. But it's important to take a stand. 97% of all convictions are plea bargains. And I just couldn't plea bargain. I did not do this. I didn't do it. And I told you guys before, I went to prison. I did that, and you'll never hear me complain or bitch about being there because I put myself there. But this I did not do. And I spent more time in Denton County sorry-ass jail than I did in prison for them to dismiss for nothing. All right, guys. Talk to you soon.